Welcome to this explainer. Have you ever stepped out your front door, looked at the landscaping right outside your unit, and wondered, wait, who actually owns this dirt? Well, today, we're going to explore the absolutely fascinating and sometimes fiercely debated world of planned community property disputes. We're unpacking a specific administrative law case out of Arizona that just perfectly highlights the tension between private use and shared neighborhood spaces.
Okay, let's dive into this. Imagine you live in a condominium complex where all the outdoor areas are supposedly shared by everyone. Then, one day, your downstairs neighbor decides to just drop down a brand new paver patio right outside their ground floor door. You probably think, hey, hold on a second. Can the homeowners association just let them build a private patio on our shared land? That is the exact neighborhood mystery we're trying to solve today. Section 1. The patio paving dispute. So we're setting the scene in Sun City, Arizona, specifically at the Fairway Court West Condominium Association. Like a lot of communities in the Southwest, Fairway was right in the middle of converting from grass to desert landscaping. Now, anyone who's ever lived in an HOA knows how intense neighborhood politics can get over the absolute smallest changes. And what started as a pretty simple landscaping update quickly brewed into a full-fledged legal conflict over who has the right to use the space right outside those ground floor condo units. To really grasp this neighborhood drama, we need to know the key players in this administrative law hearing. Back in 2002, Dave Harris purchased his unit. He'd eventually become the vice chairperson of the Fairway Board of Directors. A few years later, in 2005, Catherine Windis moved into the community. She was super active and had actually served as the chairman of the board herself in the past. For years, things were totally peaceful, but then in 2012, the HOA board passed a controversial paving resolution that just completely divided the neighborhood and brought these two leaders into a direct legal clash. To really grasp this neighborhood drama, we need to know the key players in this administrative law hearing. Here's the exact resolution from April 23, 2012 that sparked this massive debate. It reads, as part of our ongoing conversion to desert landscaping, the board is allowing pavers to be placed outside the lower lanai areas. Such installations will be considered to be limited common areas. The board set some pretty strict rules along with this. The paved areas couldn't be larger than 8 by 16 feet, the pavers had to be at least 2 inches thick, and the owners had to foot the bill for both installation and maintenance. But the real fire starter, that was the last sentence, classifying this space explicitly as a limited common area. Section 2. Common versus private property.
Now, what's really interesting about this slide is how it perfectly captures the conflicting viewpoints at the very heart of this case. Who actually owns the land just outside a ground floor condo unit? Is it shared by everyone, or does it belong to the person living right inside that door? Well, Petitioner Katherine Windis viewed these paver patios as an illegal encroachment. She argued that all property owners have an undivided interest in all common areas, and they literally pay taxes on that interest. So to her, this was a blatant land grab. On the flip side, the HOA board, represented by Dave Harris, argued they weren't giving away land at all. Many first-floor units had already enclosed their original lanais, so these owners needed basic entryway rights, just ingress and egress. The board felt they were simply providing guidance for limited common areas outside those specific doors.
To back up her argument, Windis brought out the ultimate neighborhood weapon, the community's rulebook, the CC&Rs. She pointed straight to Rule 2.03, which says that anything beyond the exterior walls is regarded as common area, jointly owned by all. She cited Rule 2.05, stating walkways absolutely must be kept clear of items like chairs and benches for easy access. And perhaps the biggest one for her case was Rule 2.21, which states that first and second floor condominiums have equal rights to the common property. She strongly felt that letting first floor owners have private paver patios unfairly favored them over the second floor owners who, obviously don't have rear ground entrances. And that brings us to the absolute linchpin of her argument, 80%. Windis argued that if the board wanted to let individuals build private patios on shared land, they were essentially transferring ownership of common property. And under state law, conveying common property legally requires the approval of 80% of the association's voting members. Since the board passed this patio resolution all on their own, without some massive community vote, she argued their actions were entirely void. Section 3. What the law says. Now, neighborhood HOA drama is intense, for sure, but administrative law hearings aren't decided on neighborhood feelings. The judge had to shift away from the emotions and look at the pretty dense legal framework of the Arizona revised statutes. The hearing focused primarily on 3 specific statutes, Section 33-117,
deals with how undivided interests in common elements are allocated among owners. Section 33118 focuses on the rules for altering or reallocating limited common elements. And Section 33125.2, well, that's that major rule Windis relied on, the 80% voting threshold you need to formally convey or sell common elements to private individuals.
And this brilliantly illustrates the turning point of the entire case, the definition of a limited common element under Arizona Revised Statute 331212. The law specifically states that any shutters, awnings, entryways, or patios that are designed to serve a single unit, even if they're located entirely outside the unit's physical boundaries, are legally classified as limited common elements allocated exclusively to that unit. It takes the legal jargon and makes it pretty plain. If it's built to serve just your door, it's yours to use.
Section 4. The judge's final verdict. So, all the arguments had been made. The CC&Rs were read, the state statutes were analyzed, anticipation was super high as the December 2012 hearing before Administrative Law Judge M. Douglas finally came to a close. It was time to settle the dispute once and for all. So, the crucial point for the judge was the standard of proof. In an administrative hearing like this, the burden of proof falls entirely on the person asserting the claim. So in this case, Petitioner Windis. And the standard she had to meet is called a preponderance of the evidence. That simply means she had to provide enough credible evidence to persuade the judge that her claim was, quote, more likely true than not. Let's step methodically through what the judge actually found. First, credible testimony established the pavers were installed specifically on areas designed to serve as ingress and egress for those first-floor units. Because these entryways are designed to serve a single condominium unit, they meet that exact legal definition we just looked at. They legally qualify as limited common elements allocated exclusively to those specific units. Therefore, the board wasn't illegally giving away shared community property at all. The judge concluded that the HOA's resolution did not violate the state statutes, and it didn't violate the community's CC&Rs either. Basically, the petitioner's whole argument was completely dismantled by the legal definition of a limited common element. The final order was crystal clear. The petition was dismissed. The Fairway Court West Condominium Association was officially named the prevailing party in the dispute. The ruling noted that the board absolutely acted within its rights to regulate these limited common spaces. A few months later, in February 2013, this decision was officially certified as final by the director of the Department of Fire Building and Life Safety. The patios could stay. It's pretty amazing how quickly a dispute over some 8 by 16-foot paving stones can escalate into a deep legal dive into state statutes, isn't it? Understanding property classifications, the difference between your private boundaries, shared common areas, and exclusive limited common elements, it truly matters to anyone living in a planned community. So next time you walk through your neighborhood, take a look around and ask yourself, who really controls the space right outside your front door? Thanks so much for joining me for this explainer, and keep asking great questions about the world around you.